Is Donald Trump still eligible to be president of the United States? Does the 14th Amendment prevent him from running? Well, as we all know, Trump was indicted 4 times in New York, Florida, Washington, D.C., and Georgia. Prosecutors in 2 of those cases alleged that he tried to overthrow the results of the 2020 election. Lawyers from the Citizens for Responsibility and Ethics in Washington, or CREW, have just filed a lawsuit alleging that Trump's role in the January 6th riot disqualifies him from running for president because of Section 3 of the 14th Amendment, which is known as the disqualification clause. This clause says that a person cannot hold office in the United States if they have previously taken an oath as an officer of the United States and have engaged in an insurrection or rebellion. So, this raises unique questions that the Supreme Court has yet to answer. Is the president an officer of the United States for the purposes of Section 3? Did Trump engage in activity that amounts to an insurrection or rebellion? And how would disqualification even be enforced? Well, let's find out. The text of Section 3 of the 14th Amendment reads, "No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof, but Congress may by a vote of 2/3 of each house remove such disability." Section 3 of the 14th Amendment was passed after the Civil War. And here's a recap of those events for Florida students who might have missed this particular history. The southern states illegally seceded from the Union, declared themselves the Confederate States of America, and then waged a war against the federal government. After the South's defeat, the people who rebelled against the United States wanted to be involved in government. Men who had violated their oaths to support the Constitution were elected to Congress. This included officers who held positions of high authority in the Confederacy, such as 4 Confederate generals, 4 colonels, several Confederate congressmen and members of Confederate state legislatures, and even the Vice President of the Confederacy, Alexander Stephens. The Republicans who wrote the 14th Amendment thought that the people who tried to overthrow the government by force shouldn't be allowed to lead it. Senator Waitman Wiley of West Virginia put it like this: "We would be faithless to our trust if we allowed the interests of the country and its future peace and welfare to be again disturbed by men who have shown themselves faithless in the past through their insane efforts to destroy this government." And that's how we got Section 3, which prohibits anyone who took an oath to support the Constitution as a federal or state officer and subsequently engaged in insurrection or rebellion against it from holding public office. This disqualification can be removed by a 2/3 vote in Congress. And this removal option is a potentially complicating factor that we'll get to in just a minute. So here's how Section 3 is supposed to work. The amendment is triggered when a person who is a current or former government officer takes an oath to support the Constitution and then engages in covered conduct. This covered conduct is insurrection, rebellion, or giving aid or comfort to America's enemies. If the official commits the covered conduct, they are disqualified for life from holding any banned office. But the mechanism of disqualification might be through a court challenge where a judge decides, or through a state law process where the Secretary of State might decide who's eligible on the ballot, but we're not entirely sure. But in the first lawsuit of its kind, Citizens for Responsibility and Ethics in Washington, or CREW, sued the Colorado Secretary of State, alleging that Trump is disqualified and can't be on the ballot for the Republican primary in that state. Although Section 3 has not been tested often since the Civil War, last year CREW successfully sued to remove County Commissioner Coy Griffin from office. Griffin is a former New Mexico County Commissioner who was disqualified from office after being convicted for his involvement in the January 6th riot. So why did they bring this lawsuit in Colorado? Because Colorado law allows any eligible elector within the meaning of the Colorado statutes to file a challenge to the constitutional eligibility of candidates in the 2024 Republican presidential primary election. Now, other states have different mechanisms for challenging qualifications of candidates before they get on the ballot. For example, 2 Florida residents attempted to get Trump removed from the ballot in that state, but a federal judge and Obama appointee ruled that citizens lack standing in that state to challenge whether another individual is qualified to hold public office. Now, the Constitution lays out the qualifications for president. That person must be at least 35 years old, a natural-born citizen, a resident of the state that he or she represents, and have lived in the United States for at least 14 years. There are also conditions that disqualify a person from running. The 22nd Amendment prohibits a person who has already been elected 2 terms as president or served more than 1.5 terms from being elected as president again. The 12th Amendment prohibits a president and vice president from residing in the same state. And CREW and the plaintiffs say that the 14th Amendment is another type of disqualification. They argue that it applies to Trump because he previously swore an oath to support the Constitution and then engaged in an insurrection. Now, it's up for debate whether the 14th Amendment acts as another qualification for president, like the age and residency requirement, or whether it functions as an after-the-fact defense. But was Donald Trump, as president, an officer for purposes of the disqualification clause? Well, the Constitution does not define the word officer. However, the Constitution refers to the president holding an office 25 times, including the oath of office clause. The presidency is an office in the executive branch, which makes it an office of the United States, and one who holds an office is an officer. So according to Crew, Trump became subject to disqualification under Section 3 when he took an oath to support the Constitution of the United States upon assuming the office of the president. Crew points out that Trump himself has conceded in court filings that the President of the United States is an officer of the United States, and point taken, but Trump's opinion on this matter is not dispositive or consistent. Here's what he said the other day, quote, "Almost all legal scholars have voiced opinions that the 14th Amendment has no legal basis or standing relative to the upcoming 2024 presidential election. It's just another trick being used by the radical left communists, Marxists, and fascists to again steal an election that their candidate, the worst, most incompetent, and most corrupt president in US history, is incapable of winning in a free and fair election." Now, that being said, there's a lot of debate among legal scholars as to whether the president is an officer or not for the purposes of the 14th Amendment. Now, Michael Mukasey, Attorney General under George W. Bush, argued in the Wall Street Journal that the president is not an officer under the 14th Amendment. He argues that the term officer of the United States in other constitutional provisions shows that it refers only to appointed officials, not to elected ones. In U.S. versus Muat in 1888, the Supreme Court ruled that, quote, "Unless a person in the service of the government holds his place by virtue of an appointment, he is not strictly speaking an officer of the United States." And Chief Justice John Roberts reiterated the point in a case where he said, "The people do not vote for the officers of the United States." And Mukasey also argued that the presidential oath in Article 2 would be, quote, "superfluous if the president's oath were required by the general language of Article 6. And for what it's worth, Mukasey's argument was enough to sway Federalist Society founder Stephen Calabresi, who had previously bought the disqualification argument. Colorado Secretary of State Jenna Griswold, the defendant in the Colorado lawsuit, slammed Trump as, quote, "a liar who has no respect for the Constitution." She also said, quote,
"If the Constitution disqualifies the former president, we have to uphold the Constitution."
But another Democratic Secretary of State seems skeptical about the effort. After a group filed a lawsuit to keep Trump off the ballot in Minnesota, Secretary of State Stephen Simon released the following statement saying, quote, "The office of the Minnesota Secretary of State does not have legal authority to investigate a candidate's eligibility for office. In the case of presidential candidates, the major political parties will submit names of candidates to our office for the presidential nomination primary by January 2nd, 2024. Those submissions will appear on the ballot for the March 5th, 2024 contest unless a court says otherwise." And he said the matter has to be decided by December 14th to comply with state law. Meanwhile, other challenges are being filed, including a lawsuit filed by one of Trump's primary opponents. Texas Attorney John Anthony Castro is running an extremely long-shot bid for the GOP nomination against Trump. And he filed a lawsuit in New Hampshire seeking an injunction that would force New Hampshire Secretary of State to keep Trump's name off of the ballot. That lawsuit is expected to be decided in the New Hampshire Supreme Court by October 23rd. And 2 Virginia citizens have filed their own pro se challenge to Trump's appearance on the ballot in that state. So you can see how complicated this is going to get as different states have different primary deadlines and disqualification procedures and powers, apart from the legal issues. But assuming the president was an officer of the United States, that brings us to the next question. Did Trump participate in an insurrection or rebellion? Again, those words aren't defined in the Constitution. Crew and the petitioners argue that the insurrection has a general public meaning. They state that a Civil War-era jury charge by Supreme Court Justice Stephen Field, sitting as Circuit Justice, explained that the, quote, "existence of the Confederate Rebellion was a matter of public notoriety, and like matters of general and public concern to the whole country, may be taken notice of by judges and juries." Justice Field explained that public documents such as proclamations of the president and acts of Congress were sufficient proof of the Confederate Rebellion's existence for purposes of charges under a statute criminalizing participation in rebellion or insurrection. Now, petitioners say that under this interpretation of Section 3, the insurrection is a matter of public notoriety. Trump participated in an event that the public understood as an insurrection. They point out that all 3 branches of government and bipartisan majorities of Congress referred to January 6th as an insurrection, and both Biden and Trump Justice Departments described those events as an insurrection, and so did over a dozen courts. Crew also points to the Griffin case where a court defined, quote, "an insurrection as used in Section 3 as 1, an assemblage of persons, 2, acting with a purpose to oppose the continuing authority of the United States Constitution, 3, by force." But one thing is conspicuously missing from the arguments that Crew is making, and that's a requirement that a person be convicted of an insurrection or incitement or that the person used violence. To be clear, prosecutions for insurrection under 18 U.S.C. 2383 or treason under 18 U.S.C. 2381, if successful, would almost certainly result in a bar to holding any office of the United States. But the petitioners are arguing that Trump didn't need to be convicted or commit an act of violence or even be physically present during an insurrection to have committed an act that triggers Section 3. They pointed out that during Reconstruction, some people were disqualified for having previously held local office in Confederate states, even though they did not take up arms in the Confederate Army. The argument is that engagement in an insurrection can include nonviolent overt acts or words in furtherance of the insurrection, including words that incite, provoke, encourage, or command others to engage in insurrectionary conduct, sort of like a conspiracy. Now, these are the kinds of issues that lawyers love and lay people absolutely hate. And if you have a similar issue and need a great lawyer, my firm, the Eagle team, can help. If you've ever been in a car crash, suffered a data breach, or need workers' comp, we can represent you or help find the right attorney who can. And for workers' comp, it's especially important to get a lawyer as soon as you're injured and not wait, which you can do right now. Just click on the link in the description for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. Link below. And now back to the 14th Amendment. And petitioners again point to the Griffin case as precedent. The court ruled that Griffin engaged in insurrection both by helping to mobilize and incite thousands across the country to join the mob, and a judge determined that, quote, January 6th was an insurrection under the Constitution, and that someone who helped to incite it, even if not personally violent, had engaged in insurrection and was disqualified from office. And Cruz's next argument is that, quote, President Trump was indisputably the leader of the January 6th mob. Without his false claims of election fraud, coercive tactics, inflammatory rhetoric, mob mobilization, promotion of political violence, instructions to march on the Capitol, and decisions to pour fuel on the fire rather than tell the mob to disperse, the attack on the Capitol would not have happened.
We're going to walk down, and I'll be there with you, to the Capitol, and we're going to cheer on our brave senators and congressmen and women. And we're probably not going to be cheering so much for some of them, because you'll never take back our country with weakness. You have to show strength, and you have to be strong.
The Crew complaint spends over 120 pages explaining Trump's acts as they relate to January 6th. And in brief, Trump led a broad effort to disrupt the electoral certification on January 6th, including telling his fans to show up on that day. He spoke at the Stop the Steal rally, and during the riot, he tweeted that Mike Pence needed to summon the courage to overturn the election results. He ignored people who urged him to intervene in the riot, instead exploiting it to pressure senators to delay or call off the vote. He didn't deploy a federal response to the attack, nor timely instruct the mob to leave the Capitol. And for those reasons, Crew alleges that Trump is barred from the ballot in Colorado. And under Colorado's presidential primary election statute, the Secretary of State is responsible for overseeing ballot access for presidential primary candidates, including determining that they meet all qualifications under Colorado law. And the petitioners asked the court to require the Secretary of State to independently investigate Trump's constitutional eligibility and rule that he is constitutionally ineligible to serve as president. Now, we don't actually know if Section 3 is self-executing, and if it's not, then federal and state courts or election authorities wouldn't have power to just determine themselves the eligibility of a candidate unless Congress enacts legislation to permit it. There's no procedure in Section 3 explaining how it should be implemented. If Congress had to enforce a disqualification clause through legislation, it could set certain guidelines, such as requiring the person to have been convicted of insurrection. And as summarized by a congressional research report, Congress initially provided enforcement of Section 3 of the 14th Amendment through enactment of the first Ku Klux Klan Act in 1870. Section 14 of that act directed the district attorney in each district in which a potentially disqualified person held office to file a writ of quo warranto against the office holder before a judge. However, Section 3 says disqualification can be removed by a 2/3 vote in Congress. And that's what happened when Reconstruction failed. 2 years after the Ku Klux Klan Act, Congress passed the Amnesty Act by more than a 2/3 vote in accordance with the disqualification clause. And the act allowed most Confederates and their sympathizers to serve as government officials again. And Congress could theoretically pass a law removing the bar from Trump or anyone that participated in January 6th. But some also argue that amnesty only operates retrospectively. For example, when a group of constituents challenged Madison Cawthorn's eligibility to hold office because of his participation in January 6th, the Fourth Circuit found that the amnesty given to Confederates does not apply to later insurrections or treasonous acts. But given the lack of case law, there's a lot of debate here, and not everyone agrees that Trump is disqualified by Section 3. Many lawyers claim that a president is not an officer of the United States, and this argument rests on an interpretation of the terms office, officer, and official. Basically, the idea boils down to the fact that one can hold an office without being an officer of the United States. Professor Josh Blackman says that there might be a significant difference between the words of and under, to wit, if a president is an officer of the United States, he can't be disqualified, but if he's a president under the United States, he can be. But that's far from a universal opinion. Law professors William Bod and Michael Stokes-Paulson say that there's no evidence that the drafters of the 14th Amendment were really using a secret code in Section 3. But the Supreme Court might be willing to engage in this kind of textual analysis. In a 2010 case called Free Enterprise Fund versus Public Company Oversight Board, Chief Justice Roberts wrote, quote, "The people do not vote for the officers of the United States. They instead look to the president to guide the assistants or deputies subject to his superintendence." So the only precedent directly on point here seems to point away from classifying the president as an officer. And Blackman also points out that Section 3 only mentions members of Congress, members of state legislatures, and executive or judicial officers, but doesn't say the actual words president or vice president. He argues because the amendment doesn't name the president is not an officer who can be disqualified. And this gets into heady originalism questions. Did the people who wrote the disqualification clause think they were exempting the presidency from its reach? Did they really think it was too dangerous for an ex-Confederate to be a senator, but not for that person to be president? And there was a discussion about this issue when the amendment was being debated. Maryland Senator Reverdy Johnson asked why the president and vice president were excluded from the language, because he thought that the president and vice president should be disqualified if they participated in an insurrection. And in response, Senator Justin Morrill, with his excellent sideburns, assured him that they were not. Quote, "Let me call the senator's attention to the words, or hold any office, civil or military, under the United States." Senator Johnson then said, quote, "Perhaps I am wrong as to the exclusion from the presidency. No doubt I am, but I was misled by noticing the special exclusion in the case of senators and representatives." And that was apparently the only time that the matter was brought up during the debate. So should we assume everyone was satisfied with the response with its implication that the president was in fact an officer? Or would we look to the first textual interpretation saying that it's clear that the president was excluded based on the explicit text? Lawyers are split on whether the disqualification clause is applicable to people who didn't participate in the Civil War, though Professors Bod and Paulson argue that the rule broadly applies to any insurrection or rebellion in the present day, not only to former Confederate officials and officers during the post-Civil War era. They say it's common for a rule that is drafted to go further than its circumstances which inspired its adoption. But there's also quite a lot of debate about whether the courts would even exercise jurisdiction over Trump's disqualification. Now, justiciability refers to the types of matters that a court can adjudicate, and when a case is not justiciable, the court must dismiss it. Standing is one example of justiciability, and the plaintiffs must have suffered an injury in fact for a court to resolve the dispute. And another justiciability issue is whether there is a political question. Courts are not supposed to deal with political questions when doing so would require the judiciary to make policy decisions, exercise discretion beyond its competency, or encroach on powers the Constitution vests in the legislative or executive branches. So the political question doctrine limits the ability of federal courts to hear constitutional questions, even where other justiciability requirements such as standing and ripeness are met. And with the disqualification clause, there's a legitimate argument that there is a lack of judicially manageable standards to decide a case on the merits. Section 3 leaves it to Congress to decide whether to remove the bar. There's no clarity on what constitutes an insurrection in this context, and courts will be reluctant to step in and make that decision independent of a criminal conviction, especially when it involves an election of the highest office of the land. But of course, all this could be moot because it seems extremely unlikely that the current Supreme Court would endorse any view that Trump is barred from attaining the presidency, especially without a conviction for insurrection. Now, obviously, the 14th Amendment could have been drafted more clearly, which the writers of the 14th Amendment could have done with today's sponsor, Grammarly, if they had had AI-assisted writing tools in 1866. Because Grammarly accelerates your writing process by generating and modifying text instantly on demand. You'll be writing responsive, thoughtful emails and posts faster than ever. It's a huge productivity boost. Plus, it's Grammarly, which I've been using for years, so of course it will help you write better than ever. And unlike other AI tools, Grammarly tailors its output for your unique context. It picks up on key details and incorporates them into what you're writing. Now, I can set my voice to be casual and empathetic, for example, if I'm writing to friends, or I can set it to be more direct if I'm writing to enemies, like opposing counsel. And of course, this is Grammarly, so it helps fix poor writing in the first place, not that I would ever do that. And I can give it prompts to make something shorter, sharper, or more exciting. And one of the coolest new features is the AI reply tool, which instantly creates a reply to your emails that picks up on context and responds and follows up exactly how you would want. It's a huge time saver. And as a content creator, I have to do a lot of script writing. And with Grammarly's features, I can rewrite my scripts to be more engaging instantly. And as a lawyer, I have to do a lot of writing and translating legal jargon into something more readable. And Grammarly's rewrite feature helps me communicate more clearly the way that I want to. Just make sure that you do all the legal research yourself. And you can even use it for ideation to give it a prompt to get ideas about what you want to write about. You'll be absolutely amazed with what you can do with Grammarly. And if you want to give it a try, you can get a 20% off discount by going to the link that's on screen right now or down in the description. Again, to get a 20% off discount from Grammarly, all you have to do is click on the link that's below. And after that, click on this link over here for more Legal Eagle, or I'll see you in court.